This conference will now be recorded.
So I'd like to welcome everybody who's joining me today for our last webinar of the month of May 2020 for National Elder Law Month. And today we're going to talk about the dangers and pitfalls of people either applying for Medicaid and VA benefits themselves or going to a non-qualified professional. And I'm going to start to share my screen with you so you can see the PowerPoint. So the topic for today, dangers and pitfalls of applying for Medicaid and aid and attendance benefits by yourself, really focuses on four important points. The first one is that we want consumers to understand that if they go to somebody who lacks the knowledge and the experience, it can cause greater problems in the application not being approved or that they are disqualified for a long period of time. The second important point to remember is that laws and administrative rules do change. Probably the administrative rules change more often in these areas than the federal laws do. And so again, if the consumer is being guided by somebody who doesn't note these rules and laws, doesn't check up when they change, they are certainly going to miss something important that's going to negatively impact the consumer getting the result that they intended. The third important point to remember is that everybody is a unique individual, regardless of their marital status. So whether it's a single person or a married couple, there is no one-size-fits-all solution that is right for every person. Everybody's going to have different financial levels, income levels, liability levels. There are always going to be different family dynamics that play a part. And so every individual deserves to get the advice that's tailored specifically to them. And last but not least, we want consumers to understand that the timing of planning and applying is very important. And again, if they're consulting with somebody that doesn't understand that, unfortunately, it's the consumer that's going to get injured. So today, we're going to touch on the following points about the statewide managed Medicaid care program. There are medical requirements, which people tend to overlook because they're focused so much on the financial requirements. You should know that when our state decided to switch to a managed care program to administer Medicaid, that there are two parts to it. There's the managed medical assistance aspect, and that's the part that would cover physician visits, prescriptive medication. It's the long-term managed care program that actually pays for the services that somebody would need should they be living at home in the community or in a skilled nursing Medicaid facility or even in an assisted living facility that participates as a licensed Medicaid provider. You'll see I've indicated in the parenthesis the word diversion because for many years that's what the community Medicaid program was called. It was called the Long-Term Care Diversion Program. So today we're going to be spending much of our time talking about the financial requirements so that you can start to understand that this is a labyrinth of rules, and it's important to understand what those rules are so that people can qualify the first time that they apply. So marital status is very important. And the second thing that's important is one spouse or both spouses going to apply, because the financial rules will change. So Medicaid looks at resources and income. So for resources, an unmarried individual is limited to having in their own name up to $2,000 of value. Now, the same rule applies to the married couple for the spouse that needs the Medicaid assistance, or who we would call the applicant. When we have a married couple, the spouse that does not need the Medicaid is allowed to keep a higher level of resources. And pursuant to federal law, the goal in allowing this spouse to have more resources is that they can continue to maintain the standard of living that they were accustomed to. Now, this figure will change every January 1st, and it's tied into federal cost of living adjustments. Currently, for the year 2020, this number has been set in Florida as $128,640. The next thing that we need to look at is the income level. And this is because Florida is one of very few states remaining in the country that also have an income eligibility requirement. So for the individual applying for Medicaid, their total sources of gross income cannot exceed $2,350 per month. This again will also be the same income limit regardless of whether the individual is married or unmarried. But if we have a married couple and both spouses are seeking to apply, then their combined income is limited to $4,700. Now, here are some examples of income. Of course, we think about Social Security retirement benefits, but it also includes pensions. So pensions from employment. Let's say the individual put money away, either in an IRA or perhaps their employer had a 401k program that they were able to participate in. All of those minimum distributions are also considered income. And under the Medicaid rules and the Medicaid law, we must look at gross, meaning before deductions come out. So it may be that when we add up all sources of income, somebody is over what we call the income limit. And in order for them to qualify for Medicaid, an attorney needs to prepare what is called a Medicaid Qualified Income Trust. This is a way of placing the excess income into the trust so that when Medicaid looks at the application, they see that the rest of the income is within the income limit. Now, depending upon where the applicant is living, is going to determine what happens with the money that is placed in the income trust every month. If somebody is living at home and receiving Medicaid services, they are permitted to use the money in their income trust to pay for their any kind of medical care, medical services. If somebody is living in an assisted living facility or a skilled nursing facility, they're going to have what is called a patient responsibility, which simply means they are responsible for remitting a certain level of their income to the facility for the cost of their care. And they will be allowed to keep approximately $108 from their Social Security retirement benefit as their personal needs allowance. Now, the first tip that I want to share with you today is that it's very important that the income trust is set up and funded in the month that the application is filed. And the simple reason for this is that if the applicant meets all other eligibility requirements except this one, they're not going to be approved. And the danger that the person runs into is if they get a notice from the Department of Children and Families saying that they have 10 days to get the income trust set up and show proof of that to the caseworker. It might be that they get the notice at the end of a month and they don't do this until the next month. So unfortunately, they will have lost that prior month of eligibility. So timing, that's one of the 4 important points I mentioned at the beginning of today's webinar, is crucial. This must be created, meaning the legal agreement has to be signed, the bank account has to be opened, and the proper sum of money has to be deposited in the month that the person is seeking to start their Medicaid eligibility. The second tip that I want to share with you today has to do with the importance of advanced planning by having the proper legal documents. So realize that when this may arise, the individual may lack capacity and may not be able to understand the need for an income trust and may not have the comprehension level to sign the document. So it's very important that clients have a well-written, durable power of attorney that gives permission to their named financial agent to create this trust for the principal. Now, resources are broken down into 2 categories. The first category we refer to as countable resources, and the second category we call exempt or non-countable resources. So this is the process by which we determine, is somebody within or are they over the resource limit? So the first and probably the most important resource for every client is their home. So up until a few years ago, Florida had an unlimited exemption for the value of the home. And then that changed and they did place a limit on the value. Again, that is one of the values that will change every calendar year. For this calendar year, we can protect a home so long as the value does not exceed $595,000. If it does exceed that amount, then the amount over this limit would be counted as part of that overall resource limit. The Department of Children and Families Manual also permits a person to have 1 automobile, regardless of value, and they can have a second automobile as long as that automobile is more than 7 years old. If the client has retirement kinds of accounts, what are sometimes under the tax code referred to as a qualified account, such as an IRA, a 401k, or a SEP account, the rule is that if the owner is taking minimum monthly distributions, then the principal investment value of that retirement account is exempt as a resource. And they will only look at the monthly distribution under the income rules that we were just talking about a minute ago. Believe it or not, there is a rule about funeral arrangements. And the reason for this is simply because Medicaid wants to make sure that the individual who owns the funeral arrangements cannot pull cash out of the contract. So their rule is that there is a $2,500 limit on what can be spent on funeral arrangements. If the person wants to spend more than that, and that probably would only cover cremation, it would not cover burial arrangements, then the contract must indicate that it is irrevocable. Irrevocable meaning that should the client later change their mind about what they have purchased, maybe they want to change the services or the merchandise, and it would cost them less, the funeral home is not going to refund them the difference. And so that's how DCF knows the client cannot get their hands on cash. So $2,500 is the limit, but if the contract is made irrevocable, then there is no limit as to what can be spent on the funeral arrangements. Some clients may be receiving reparations from foreign governments, and so we have an exclusion based on federal law that is honored on the state level. So reparations will not count as either a resource, nor will it count as income. And there is no time frame within which the reparations have to be spent. What we want to preferably see clients do is to keep the reparations in a separate account rather than commingling them with other assets that perhaps the client accumulated over years when they were working. Now, what if the client not only owns their home, but they have a second piece of real estate? So there are separate rules regarding the non-homestead property. For example, if that real estate is listed for sale, Medicaid will temporarily not count it, so it is also an exempt resource. If the client owns this second piece of property with a joint owner, and the joint owner refuses to list it or sell it, and that's something that would have to be put in writing, then the Department of Children and Families will also, for that reason, exclude the non-homestead real property. Now, there are minefields to be watching out for. And this is where, unfortunately, the consumers do get hurt when they go on the internet. They're reading things that are not accurate or not up to date. Or perhaps they're talking with a next door neighbor and they receive misinformation that way. So the first thing you want to know is that many years ago, Congress changed what is called the Lookback Period. And the reason Congress did this is there was the perception that people who were able to either buy long-term care insurance policies or able to financially subsidize their own future long-term care costs were not doing so. And they were giving away their assets and applying for Medicaid. So we went from a 3-year look-back period to a 5-year look-back period. The look-back period means that when an individual submits their application to their state Medicaid agency, the application will ask them whether they have transferred any assets out of their name within the last 60 months, 5 years. If they answer yes, the next question will ask them to identify when they made those transfers and the amount. And it does not matter whether it was cash, whether it was a check, whether it was in the form of stocks or investments or real estate. Everything is looked at. So you want to understand that the only relationship protected when it comes to the look-back period is the marital relationship. And it would make sense to mostly everybody because under federal laws, we see that married individuals are treated preferentially. We see it in the tax code, for example. But once we go outside of the marital relationship, let's say there's a transfer from a parent to an adult child, there is no protection. And that kind of transfer is subject to scrutiny by the state Medicaid agency. Now, one of the other changes relating to the look-back period is that under the old law, if somebody did make a gift, they did transfer an asset, the penalty, as we call it, meaning the period of time the individual is disqualified to receive Medicaid, would be calculated based upon when the gift was made. And so we actually could calculate when the penalty would run out and when it was safe to apply. Well, when they increased the look-back period from 3 to 5 years, they also changed that rule. And rather than looking at gifts individually and the dates they were made, they accumulate all transfers within the look-back period to get one total value. And then they apply a math formula to determine how many years, months, weeks, or days of disqualification is going to apply. Now, here's what unsuspecting consumers don't understand. They don't understand that that penalty period is not going to start from the date of the last transfer. That disqualification period is only going to begin when the consumer files their Medicaid application, bringing it to the attention of the state Medicaid agency. And that's when the clock starts to tick. So the individual will receive a denial notice, but it starts the disqualification period running. And so during that disqualification period, the consumer needs to be able to pay privately for their care until the penalty expires. At that point in time, they can file, or with their attorney's assistance, file a second Medicaid application, and they will be approved at that time. The third minefield that many consumers are not aware of, and they're not told this by insurance agents, is that annuities, which used to be used fairly often, now must name the state of Florida as the first beneficiary if there's any money remaining in the annuity when the annuity owner dies. So many years ago, people would buy annuities before they retired as a way of planning to replace their employment income for their retirement years. And people started buying annuities as well, thinking that they would be able to shelter resources from counting under the Medicaid rules. So again, when Congress made that change to the 5-year look-back rule, they also changed the annuity rule because they needed a way of recouping some of the monies that are paid out on behalf of Medicaid recipients. So if an individual does not have a spouse, they're allowed to name the spouse as first beneficiary. But if they don't have a spouse, they must name the state of Florida first, and then they can name their children or other beneficiaries as second beneficiary. And this is how Florida has been able to recoup more of the Medicaid assistance that it has paid out. So unsuspecting consumers who are not apprised of this by insurance agents are going to be, well, they won't be surprised because they will have passed, but their family members are going to be surprised when they find out they may not be receiving any portion of what remains in the annuity at death. The fourth minefield, and this is more recent, this is a change from 2019, is that Florida is no longer providing 3 months retroactive Medicaid benefits. In late 2018, Florida applied to the Center for Medicare and Medicaid Services for a waiver. They asked to be relieved of having to provide applicants with retroactive Medicaid benefits in the event they didn't know they would have qualified, and so they filed later than they should have. And CMS granted that application on a temporary basis for the waiver. That application waiver is still in effect. CMS has not required Florida to go back and provide retroactive benefits. So this is very dangerous, again, for the unsuspecting consumer who doesn't get the right advice. And when they apply, they learn that Medicaid is not going to pay the nursing home for the last 1, 2, or 3 months before they apply. So this is very dangerous, and we need consumers to go to qualified, specialized attorneys who do this area of law every day of their practice. Now, earlier you heard me talk about that there is no one-size-fits-all solution, that every person needs to have a plan that is tailored to them under the law, so that they can maximize what they're allowed to keep under the law. And it's very important because not everybody's circumstances are the same, and we don't want to tell one person to do something that's really not in their best interest based on everything going around in their family circumstance. So for example, if we have somebody who owns a home, but they haven't taken the time to really take care of it in recent years, and it needs improvements, it needs maybe a new roof, maybe a new fence, or they still have a mortgage, then we want to tailor the plan to them to let them know that they can use some of their excess resources to pay for the improvements, pay for the repairs, and either pay down or pay off their mortgage. Since the home is an exempt resource, anything that the owner does that improves the resource, improves the value of the home, is a permissible expenditure of their excess resources. Let's say we have a married couple, and maybe they're in a second marriage. They have children from former relationships, and they specifically wanted to keep their assets separate. Maybe they even have a prenuptial agreement. Well, knowing those specific facts about that couple, we may want to be recommending that the spouse who's healthy use the federal law called spousal refusal, which means they can keep more than the resource limit as a spouse. They don't have to change anything about their resources, and their spouse can still qualify for Medicaid assistance. Now, in order for this to work, a couple of things need to happen. First, the spouse who is not applying for Medicaid is going to be asked to sign a form as part of the Medicaid application process, which says that they are refusing to make their resources available for the support of their spouse. For some people, this can be very emotionally trying. And again, this is not going to be the right plan for every person. That's why we need to get to know our clients and understand them as people, not just based upon their wealth. The spouse who's applying for the Medicaid needs to sign a different form that says if they have any rights to support from their spouse, they are assigning those rights to the state of Florida. Now, for those of you that might be practicing in the family law area, you'll know that we do not have the old English common law of dower or courtesy, which required the husband to provide support for the wife. We also have a Florida Supreme Court case that comes out of Miami-Dade County that stands for the proposition that simply by being married, you are not legally responsible for the debts of your spouse. So based upon those two things, we've taken the position that the state of Florida should not be able to pursue the healthy spouse for any kind of support on behalf of the Medicaid applicant spouse. That's not to say that things will not change in future years. In states such as New York and California, which have very well-funded Medicaid programs, and when I say well-funded, I don't just mean the amount of money going into the programs, but their Medicaid offices are very well staffed. In those states, what we've seen is that the legal department for Medicaid will send a demand letter to the community spouse, the spouse who's not ill, and they will request that that spouse pay a certain sum before Medicaid will pay for their spouse. And if the community spouse ignores the demand or they refuse to comply, what New York and California have done is they file a lawsuit against the community spouse seeking support under state law. But those cases generally do not go to trial because no one would want these kinds of cases to be brought before a jury of their peers, who may very well include older adults in similar situations. So these cases get resolved based on negotiation for pennies on the dollar. That is not what has happened in Florida since using spousal refusal. What happens is once those forms are filed, the caseworker reviews the application based solely on the applicant's resources, income, and any transfers. So they look at them as if they are an unmarried individual. Another possible tool we may want to use when tailoring a plan to the individual is to know about their children. Do you have a child that's been caring for you, that maybe reduced their work schedule, or maybe they even gave up outside employment? So when we hear that set of facts, we can consider transferring ownership of the home to that adult child, so long as they can document that they cared for their parent for at least 2 years, which delayed the parent having to go into an institution, whether it be assisted living or a skilled nursing facility. And so that's a very rare exception to the transfer of resources rules. Another tool we may want to consider is if we learn that somebody in the family has been providing caregiver services to the elder. Let's say they are doing things around the house to maintain the home. They might be handling the finances and bill paying. They may be overseeing and coordinating medical care and treatment for the elder. And then we're going to want to explore the possibility of compensating the caregiver for their time. And this is what we refer to as a personal service agreement. So when we have the right set of facts and it is documented, the elder can pay the caregiver for their services, and it does not fall within that look-back period rule, and it is not a transfer that can cause the elder to become disqualified for Medicaid. Age is also very important because that also impacts which planning tool is right for the client. So if we have a client under age 65, and again, we're going to look at marital status, we're going to look at what the assets are and what the value is, we might consider what is called a special needs trust. So special needs trusts and pool trusts were created under federal law back in 1993, part of the OBRA Act. And Congress decided to allow people under age 65 to place their resources in the special needs trust and qualify for programs such as Medicaid and SSI. The reason Congress allowed this was because the individual is not allowed to have access or control over the trust. So somebody else has to serve as the trustee. It is also within the trustee's discretion when to use, when to apply the money, what purchases to make. And the other reason that Congress agreed to exclude these kinds of trusts is we all know that there is no such thing as a free lunch from the government. So a special needs trust must have what we call a payback provision, which means there is language in the trust agreement that says when the trust beneficiary passes away, Medicaid gets the first bite at the apple. So we look to see, are there monies remaining in the special needs trust at the death of the beneficiary? We contact the state Medicaid agency and we ask them for the amount of their Medicaid lien, and then that lien must be paid. If after the lien is repaid, there are any monies remaining, then those monies can be distributed to any designated beneficiaries under the agreement. But we're only allowed to use this kind of trust with clients that are under age 65. That is the cutoff. So if we have a client that is over 65, we can use the pool trust. Now, we can also use the pool trust for somebody that is under age 65 as well. And I'm going to first explain how these two trusts differ, and then explain why somebody who's even under age 65 might benefit from the pool trust. So with the special needs trust, our clients can choose whoever they wish to serve as the trustee. But under the federal law, a pool trust must be managed and operated by a 501c3, which means they must be a charity under the Internal Revenue Code. So I, as the attorney, cannot serve as a trustee. Family members cannot serve as a trustee. Also, what differs is that a special needs trust is written and intended to benefit just one individual, whereas the pool trust is intended to benefit multiple individuals. So if you think of the word pool, people are pooling together their excess resources, placing them in this trust, which is managed by a non-for-profit charity. And the trustee is overseeing it, determining how to properly invest the monies. They provide an annual accounting, and they oversee the expenditure process. So with the pool trust, it can be more economical if the amount of money that somebody wants to place in the trust is not of a level where a professional trustee would be willing to take on the responsibility as a trustee. Many professional trust companies have a minimum threshold level that starts at about $500,000 and goes up from there. So if somebody had $50,000 that they wanted to preserve, it's not going to be economical to have the attorney draft the special needs trust and then have a trustee administer it. It's probably going to make more sense for the client to consider selecting a pool trust company, and then they're not paying any kind of fee to have the trust created. They're just paying the annual administration fee to the trustee. So that's why we sometimes consider this for people that are under age 65, as well as people over age 65. Now, we have many different pool trust companies in the state of Florida. Each one, as a charity, has a different charitable purpose. Some of them are tied into a religious charitable purpose. Others may represent a certain community or population. So they may serve people who have, for example, autism or other disabilities. It doesn't mean that a person applying must have that disability or must observe a certain religion. It's just so that the applicant knows what the purpose of the charity is. Now, a pool trust, similar to the special needs trust, is also required to have that payback provision under the federal law. However, some pool trusts have an agreement with the state of Florida that allow any remaining monies to be split between the charity to further the charity's purpose and repay Medicaid. There are some pool trusts that have an arrangement with the state where a certain amount goes to the state, a certain amount stays with the charity, and the balance can go to the beneficiaries designated by the individual. So this webinar would not be complete if we didn't have a discussion about what's been happening the last few years in the state of Florida, which is the unauthorized practice of law by non-lawyers. So you may see when you're driving on the road a billboard, or you might see a car that is wrapped in advertising that gives the impression that they're somehow related to the government. They may show a picture of the American eagle or the American flag or some other symbol that leads the consumer to believe that this person, this company is very official. They're related to the government somehow. And so individuals and even non-lawyer professionals years ago started deciding they were going to give legal advice to consumers about how to qualify for Medicaid and for veteran aid and attendance benefits. And this includes even former Department of Children and Family caseworkers who left the agency and went to open up their own business. It includes insurance agents and financial advisors. The problem that the elder law section discovered was that these individuals had no idea what they were doing. They didn't know the rules or the laws, and they were really just financially benefiting themselves, or they were selling these consumers an insurance product that benefited the agent. We learned that the clients never met with a lawyer. So even if the non-lawyer said, I'm speaking with a lawyer on your behalf, the client never met the lawyer. They never formed an attorney-client relationship. They never had the benefit of knowing there was more than one planning option. So what happened around 2015 is there were enough complaints that we were hearing about that the elder law section took this matter to the Florida Bar President, and then it was taken up to the Florida Supreme Court. There was testimony given by consumers who had been injured by non-lawyers, and as a result, the Florida Supreme Court issued its written opinion as to what constitutes the unauthorized practice of law by non-lawyers when it comes to Medicaid. Unfortunately, even though that opinion came out, things have not changed all that much. What did change is many of these individuals started to associate themselves with lawyers. But again, they played the middleman, which meant they didn't allow the consumer to meet or communicate with the lawyer. Again, the consumer got injured by not getting the right advice, or they didn't give all the information because the non-lawyer didn't know what to ask for. So I want to share with you some examples of the cases that were brought and the testimony that was brought before the Florida Supreme Court, just to show you how real the harm to the consumers had been in the last few years. Advice has been given to consumers without telling them that there are potential tax ramifications, whether it's due to transferring assets or a personal service agreement, which might trigger employment taxes, income taxes. And so the consumer finds out later, and then they realize that they were able to keep far less money than they were led to believe. Or one of the worst scenarios we saw was a parent and an adult child who were told to form a personal service agreement, stating that the daughter was providing all kinds of services to the parent, when in reality, the daughter never provided any services. And so both the parent and the child signed this legal document containing false statements. When it was being investigated by the DCF caseworker and district legal counsel, they discovered that both the parent and the child had lied, and they were charged with Medicaid fraud. The parent's Medicaid application was denied, and DCF has taken the position that they will never in the future approve this parent for Medicaid because of what was done. And this is all because of the advice that they received from non-lawyers. Another thing that we see is that the non-lawyer prepares the Medicaid application and fails to identify all the income sources. So the client, the consumer, has no idea that they're over the income limit and they need a qualified income trust until they get a notice from DCF saying you have 10 days to show us that you've established a qualified income trust. And many times they can't get it done that quickly, and their application is denied. The other thing we see is that the person preparing the Medicaid application doesn't understand what are countable resources, what should be looked at. So all the countable resources are not identified on the application. And the caseworker runs the applicant's name, date of birth, social security number through all government computers, and they find out that there are countable resources not listed on the application. So again, as you imagine, the application gets denied, and the consumer is behind the 8 ball and is harmed until they get the right advice. You know, I can't stress enough that it's important that everybody's plan be tailored and be unique to them. One of the worst things that these non-lawyers do is they fail to identify and inform the client of all the options and which ones are best for the client based upon the client's financial circumstances. Now, in the remaining time we have, I do want to share with you some updates about the Veteran Aid and Attendance Benefit Program. We have new rules that are a year and a half old, and we saw this coming for many years. There were bills pending in Congress attempting to make the aid and attendance financial eligibility requirements similar to the Medicaid requirements. Now, up until October of 2018, there were very low thresholds of resources that the veteran and their spouse could retain in order for the veteran to qualify for financial assistance. So in October of 2018, Congress changed that rule, and now the net worth, regardless of whether it is a single unmarried applicant or a married couple, it's the same net worth value. And again, this may change year to year, it may increase, but currently it's set at $129,094. What is not included in the net worth of the veteran and their spouse is the value of their home, very similar to Medicaid, and a car. What was the real big change in October of 2018 is that the Veterans Administration had never previously had any kind of look-back period. So there was no transfer of asset penalty. And that's what they changed to make it as close as possible to the Medicaid rules. So we now have a transfer of asset penalty rule. It is a 3-year look-back, unlike the Medicaid 5-year look-back period, but I would anticipate that somewhere in the next few years, they will probably raise that to meet the 5-year Medicaid look-back requirement. So again, we don't want unsuspecting consumers to be duped and told to transfer assets, and then they go and they file and they end up getting a notice of disallowance, which basically means that they have been denied benefits. The Veterans Administration, unlike the Medicaid agency, has for many years been aware that there are people holding themselves out to the veterans, telling them that they can help them qualify for aid and assistance benefits. And so many years ago, the VA instituted a rule that in order to counsel a veteran, an individual or a company must go through an accreditation process. And part of that process is to continue on an ongoing basis your knowledge, your education level about the VA rules. The second requirement that the VA has is that even an accredited agent is not allowed to charge the veteran or their spouse for assisting them with completing the application process. Accredited agents can charge for advice, and then the other time frame when they can charge is during the appeals process, meaning the application is denied, and now the veteran is going through the administrative appeal process. Accredited agents are not allowed to benefit by selling any kind of product, such as an insurance product. So be careful, watch with open eyes, ask people about their qualifications, have them show you their proof of their accreditation. And what many consumers don't realize is that every county has a local VA office that is staffed with retired veterans They can assist the veteran with filling out the application and filing it. They perform a wonderful service. I've had our Broward County Office of Elderly and Veteran Services go out to people's homes, go to the veteran who might be in a hospital, and assist them with this application process. So this is a great resource within our community that many times goes untapped. And I hope that you will share this information with your clients, with your colleagues, and with your neighbors. So at this time, I'd like to open either the chat box in case anybody would like to type a question into the chat box, or you're welcome to unmute your microphone and I'll be happy to answer any questions or concerns.
Stephanie?
Hi, Jill.
Hi. Sorry I got on a little late. I had to do this on my phone. My computer doesn't have, we're getting new monitors that have microphone, have video within, cameras within the screen. Okay, so the question I have is, where I'm really uncomfortable with ever recommending anyone other than an elder law attorney that will address VA benefits is because I think most often people don't understand that really Medicaid is the bigger payer source for their long-term care needs, right? So much of the time if you were to send somebody to, somebody who specifically deals in VA, but yet they don't understand the issues around Medicaid, I feel like we're doing our clients a very big disservice. I don't think one can really be addressed without the other.
I would agree with you. When somebody is fortunate enough to have served as a veteran, they have two programs and they don't always have to choose, and so part of planning might be to figure out, can we simultaneously qualify the consumer for aid and attendance benefits as well as Medicaid, especially if the consumer is still living at home and their preference would be to have a home health agency come to their home to provide the services for as long as possible. So having that aid and attendance benefit, which is a financial monthly stipend, can really go a long way in addition to possibly getting them qualified for the community Medicaid program.
I had another question. Can you, oh, I'm sorry, someone else has a question.
Debbie, did you have a question? I see you unmuted. Debbie, did you have a question?
No, it was basically, could you get both Medicaid and aided attendance at the same time?
You can, and it's just a matter of doing a proper assessment to determine how that can be achieved.
Okay, thank you.
And one thing to keep in mind, and again, this is something most individuals don't know, is when you have a married couple, if it turns out that the veteran is healthy and they're not going to qualify for aid and attendance, because again, like Medicaid, it's not based purely on financial criteria, there's a medical component to it. So if the veteran is healthy, we cannot get aid and attendance benefits for the spouse who is ill.
Right.
The spouse's benefits are triggered off of the veteran's benefits. Now, if the veteran has passed, then the widow or the widower can apply on their own, as long as they meet both the medical and the financial requirements.
Thank you.
You're welcome. Jill, did you have another question?
Yes, on the special needs trust, can you go over that component briefly? Were you stating that on a special needs trust, a family member cannot be the trust? You didn't say the family member cannot be the trustee. trustee of a special needs trust, correct?
Correct. I did not say that. What I explained is the law only allows a pool trust to be operated by a charity as opposed to a human being.
Okay, got it. Okay.
And Stephanie, could you address
Okay.
the life estate in with a child? I'm encountering some questions about that when there is homestead property or home in which the elder lives and life estate established long ago to the children. How does that impact the assets?
Okay, that's a great question. Thank you for sharing it with us. I'm going to ask everybody else to mute their mic so again, we don't have background noises or interference. Thank you. So there are many different ways that a deed, which signifies the legal ownership of real estate, can be written. And Emily is asking about a deed that is written in a way where the parent as the owner keeps a portion of the ownership, but gives a portion of the ownership of the home to an adult child or perhaps multiple adult children. It depends how it's written. If it's written in one way where the adult child gets immediate ownership, that will fall under that 5-year look-back transfer rule that we discussed earlier. And so we would need to wait until that 5 years is over before applying. There is a second way to write a deed like that, but not give the adult children ownership rights now while the parent is alive. So because they don't have ownership rights now, it's as if nothing was really transferred to them. And so that type of deed is the more preferred one to use because then we don't even run into the transfer look back period.
Yeah, and during the life of the elder, then, is the life estate an asset that is counted?
No, it is not. It is still excluded.
Okay.
And in the view of the Medicaid agency, it says if the elder has full ownership and full control.
Okay. Is that true in nursing home settings as well as the home community?
Yes, this is a rule that applies regardless of the Medicaid program.
Okay.
So I'd like to thank everybody for joining me this Friday at the end of what I imagine has been a very long week for all of you. And I hope that you will share this information, and we are developing our June calendar of webinars. So as soon as we do that, we'll send out invitations, and I hope that you will join me then. So I wish you a healthy, safe, and a fun weekend. Thank you for joining me.
Thank
Thank you very much, Stephanie.